morning. Please be seated. The next matter is Chelan Basin Conservancy versus GBI Holding Company and City of Chelan and others. First, we'll hear from Brendan Donkers for 10 minutes. Then Jay Geck and Eric Miller will be splitting the response. And then, Mr. Donkers, you'll have 10 minutes for your rebuttal.
Thank you, Your Honor. May it please the Court, Brendan Donkers here on behalf of the petitioner, the Chelan Basin Conservancy. This case asks the Court to apply the public trust doctrine. The public trust doctrine gives the public a right to navigation, the fishery, and the corollary rights of recreation across navigable waters. This Court has said that the public trust doctrine is paramount and inalienable. This Court, in this case, asked the Court to apply that doctrine to a specific fill that's lying on the southeast shoreline of Lake Chelan. It's called the Three Fingers. And I've asked the bailiff to share a picture of the Three Fingers with you. You can see the illustration of why it's called that. This Court may be familiar with the Three Fingers. There's a display upstairs that talks about the Wilbur v. Gallagher case. The fourth finger that was at issue in that case is to the far right of the photo that you see. And to the left is the former town of Lakeside. The trial court concluded that this fill violates the public trust doctrine, that it's a public nuisance, and that it needs to be removed. Now, there are two distinct aspects to the state's ownership of the shorelands and tidelands. One is the use privatum. The use privatum is mentioned in Article 17, Section 1 of the state constitution, and that gives the state title to the shores and beds of navigable waters. The second aspect to ownership is the use publicum. And the use publicum is the public's right to navigation and recreation. The use publicum, as this court has declared in cases going back more than 100 years, is paramount and inalienable. It can no more be given away than can the state abdicate its police powers in the administration of government or preserving the peace.
Are you arguing, I'm sorry, I didn't get this earlier, but are you arguing that Article 17, Section 1 is the expression of just the use privatum principle and not the use publicum principle?
Well, the Rakowski decision addresses this, I think, Your Honor, and what the Rakowski court said is that Article 17 partially encapsulates the public trust doctrine.
Right, but I wasn't sure which part of it.
Right. It's the public trust obviously is an ancient doctrine that goes back to Rome, and it has common law origins, but there is a constitutional component to. But
it sounded like you were saying the constitutional component only goes to the privatum aspect, the title aspect, and not to the publicum aspect.
Well, our position is that the article incorporates the use publicum. And that is because with the state's ownership of the tidelands and shores, which can be conveyed through title, the use publicum is a trust that is held within the state. So with the ownership of the beds and shores of over navigable waters, the state, part of sovereignty means that the state continues to hold that right of navigation and recreation and trust.
But you don't need the Constitution to tell us. We don't need the Constitution to tell us that if it's an inherent aspect of sovereignty.
No, I don't think you do. But it is there. I don't think it's necessary. The court hasn't directly stated that it is a constitutional issue, although some of the language in the Caminiti case suggests that Article 17 does incorporate the use publicum. I'm hesitant to say that it is specifically in that within that article. I know Justice Wiggins has done some work with understanding the Constitutional Convention and the battle over the tidelands and shorelands, but it is the use publicum is incorporated in that article.
Well, thank you. I have done some work in that area, and the thing that puzzles me about this is that the largest battle in the entire Constitutional Convention was whether the state could sell tidelands, whether the state could sell shorelands, or whether all of that should be prohibited. And they opted out by not declaring whether they could be sold or not. And I don't really understand how this common law doctrine can come into play when the delegates to the convention walked right up to this issue and didn't adopt it, a restriction on alienation.
Well, the doctrine comes into play because it's always existed in the state of Washington. Caminiti made very clear that the doctrine existed, and the state's title is still subject to the state's sovereignty and dominion that includes it exercising the public trust in navigation. And so it has always existed that the state constitution gives the state title, gives the right to sell and convey lands. The state still reserves the right to hold this doctrine of the right to navigation and recreation in trust for the public. And that's what we've just seen in decisions from this court, most recently in the Whedon case in 1998, and then in the Orion Corp case in 1987, where the court is looking at how a statute applies under the public trust doctrine. And Caminiti, of course, adopted a two-step test. Does the statute surrender the state's control over the jus publicum? If so, does the statute impair the public's interest in the jus publicum, or at least does it not substantially impair it? And so the lingering issue with these cases, the public trust cases I'm referring to, is that this is a doctrine that exists, and it is the power and in the authority of this court to review whether a statute that impairs the public's right to navigation is improper under the public trust doctrine.
Would you advocate that it's unconstitutional, and if so, which specific provision are you asking us to invalidate?
Well, we're asking the court to apply the savings clause of the Shoreline Management Act, which is what has been relied on by the owner of this fill, the owner of the Three Fingers, as a defense to removal, as a defense to the public trust doctrine. And an as-applied challenge doesn't ask the court to invalidate the whole statute. An as-applied challenge applies the statute to the specific circumstances before the court. And in this case, you have an unused, unproductive pile of dirt and rocks that sits on the southeast shoreline of Lake Chelan. And so the as-applied challenge is only in the specific context of fills that are essentially unused and unproductive.
So can I push back against that, I guess, a little bit? Because it seems to me that your argument based in the public trust doctrine, whether you specifically tag it to Article 17 or look at it more globally, shouldn't even admit of the savings clause. Because why would the state under the Shoreline Management Act have the authority to say these fills, docks, structures, whatever, that violate the public trust doctrine are fine, except these few? I'm not sure I understand why that argument would even accept the savings clause.
The public trust doctrine?
Right.
Well,
why it wouldn't require a structure by structure, fill by fill analysis that you advocate for under Caminiti.
Exactly. That's exactly why we're saying this statute is a problem.
Okay, so if you're relying then on the proviso to the savings clause, why isn't that just a sub-constitutional argument? Maybe a constitutional avoidance interpretation, but I don't understand why that's at all a constitutional argument.
Well, the problem, I think what the trial court concluded was that it was an alternative theory to avoid the constitutional questions raised by the public trust doctrine, and that in this specific case, the fill constituted a public nuisance. And so I think it's an alternative theory that the trial court adopted. We didn't raise a public nuisance as a part of our complaint. It was something that the trial court concluded based on the record.
The case, it seems to me that there's really just one main question in this case, and that is whether your opponent is correct when they assert that the legislature gave post hoc consent to the fill under the savings clause. And if so, what was the extent of the consent given? Specifically, what does it mean when it says in trespass or in violation of state statutes as the proviso? What does that mean exactly? I think trespass we understand, but what statutes are we talking about?
Well, certainly the nuisance statute, Title VII.
But the nuisance has to be other than something that's in the water. It has to be a nuisance on its own, right?
No, we don't agree to that. I mean, there's no language in the proviso that suggests that the nuisance statute should be read out of the language of the proviso. And going back to the issue raised by Justice Stevens, our position is that a categorical abdication of the state's control over pre-existing feels is the problem with the savings clause, that the legislature shouldn't have given such a sweeping allowance to all fills simply because they existed prior to 1969.
So instead of a post hoc authorization, we need post hoc approval of the post hoc authorization before the fill is okay. Is that?
Well, there should be some level of review, and this is what the Arizona court looked at in a 1991 decision that we cited, where the court there relinquished title to riverbed lands just as a categorical matter. And the Arizona court came back and said that you couldn't do that. You needed some kind of particularized mechanism to evaluate what the impact to the public trust is by each relinquishment of the parcel.
And you believe Caminiti is that test, or?
Caminiti is the test. That's right, Your Honor. The two-step test that says, has the state abdicated its control? If so, is there any public interest that's promoted in the use publicum, and or is the use publicum not substantially impaired? Caminiti is the test.
So why is that test not a substitution of our policy preferences for the legislature's policy preferences?
Well, that's a good question, Your Honor. Our response would be that the court retains the inherent authority to review legislation. So it's not just the legislature's right to give up the use publicum as a categorical matter. This court retains that authority. The Caminiti test is what the court has applied in evaluation of legislation that impairs the use publicum. So Caminiti is the test, but it is the court's authority to evaluate legislation under that test. Thank you.
Good morning, Chief Justice Fairhurst. May it please the court. Jay Geck, Deputy Solicitor General for the state. There's two steps in this case. Did the state consent, and what does this proviso mean? And second, is the proviso statute valid? Is the consent statute valid? I want to turn first to what does this proviso mean, and we think it means something a lot narrower than the Court of Appeals said. The proviso excludes the consent. Let me take this back one step. But the consent is given in order to bar Wilbur claims after Wilbur. But it is not to bar all Wilbur claims. It's to bar Wilbur claims except for on property where there's a trespass or where there's a violation of statute.
So if the fill had been in violation of a treaty with one of the tribes, this wouldn't purport to save that in any way, would it?
Correct. That would be, it would have no effect, of course, on a treaty rights claim. But second of all, the statute's very careful to say that it only limits private actions under Wilbur and has no effect on state pollution powers, state nuisance powers. That's subsection 3 of the statute. And those powers being preserved are something that the Court of Appeals opinion didn't give proper credence to. The error here is really, and the issue that is framed here, is what the Superior Court did. It said that this proviso was triggered by an impairment of navigation. That makes no sense of the statute. Part 1 of the statute gives consent to an impairment of navigation in order to bar Wilbur claims. If the proviso says impairment of navigation triggers the proviso, then by definition the statute has no effect anywhere. And so we simply apply 4 basic rules of construction, look at the words in context. Impairment of navigation can't both be the consent and the proviso trigger. We also look at the legislative history, which was there was an intent to deal with otherwise legal fills that were not in trespass. And you look at the rules of narrow construction. A proviso should not, swallow the rule. And you look at the rule that to avoid an absurdity. And all those point to the fact that the Superior Court's analysis of this proviso was error. It did not. The proviso was not triggered by the mere fact that the fill was impairment to navigation.
Then can you walk through, because the proviso says trespass or violation of state statutes. The lower court, as you point out, relied on nuisance statutes. So maybe walk through why you think that's a misreading of the state nuisance statutes.
Well, the state nuisance statutes are capable of being applied to things that obstruct waters. But when the legislature also has strong power to define what is and isn't a nuisance, and by adopting this law here, by giving consent to a Wilbur claim and saying with the proviso, except when violates statute, you can't have the violation of statute also be just the mere impairment of navigation. So that's the only carve-out we really need to make. We know that that can't be the impairment of statute that's referred to by the proviso. The other impairments of statute, the other violations of statute that we think would trigger this proviso would be things like that we've listed in some of our briefing. There's statutes concerning fish passage, there's statutes concerning heights of bridges and so forth. Any of those would still, the property be
So
subject
can
to
I ask you this?
overlay.
This is one thing I was thinking about. If we're just reading the nuisance statutes and the full breadth of those statutes, if someone wanted to challenge a fill that was made in, let's say, 1978, could that person rely on the state nuisance statute to say this fill impairs navigation and needs to come out?
Absolutely.
Okay, so it's a different interpretation of the same statute, read, I guess, in peri materia with the Shoreline Management Act?
Correct. You have to read the two together and make them harmonious. And it's clear that the legislature, by giving consent, could not have simultaneously taken that consent away with the proviso, because that leaves the statute with no meaning whatsoever. Turning to the validity of the statute, the Caminiti case controls this, and we think that the plaintiff's argument would drastically alter this court's review of legislation under the Caminiti test. Now, the Caminiti test is a common law test, and it refers to the state's power over navigable waters. And under Caminiti, when the law, like the Shoreline Act, imposes substantive controls on property, that's not a loss of control for purposes of a disposal of the jus publicum. And therefore, there's no violation of the public trust as a threshold matter. But even if you artificially take this bar to Wilbur claims, because that's all 270 does, is bar some Wilbur claims, if you take that out of context and say, well, maybe that's a disposal of the jus publicum, that doesn't violate Caminiti for two additional reasons. First, there's no substantial impairment of the jus publicum in the lands and waters remaining, and that's this court's test in Caminiti, and that's this court's test that it relied upon in the Illinois Central test.
Is it the waters remaining now or at the time of the fill that we consider?
I think the focus on that, based upon the Illinois Central roots of the Caminiti case, are the water body that is being affected, because there's a jus publicum in every water body, but there's not a jus publicum on every square foot. If there were, then this court's decision in Orion said the opposite. This court's decision in Harris versus Hylaba said the opposite. Portage Bay, East Lake, they all acknowledge that we have 100 years history of developing and using shorelands and tielands and navigable waters. So there's not an inviolability of, inalienability of every square foot. But you look at the waters remaining, and what you're looking for is something like the giving away of Chicago Harbor. Chicago Harbor was given away by one law of the Illinois legislature. When they took it back, they had to go to the U.S. Supreme Court to defend that action, and that's where the Illinois Central case came from, is that that sort of a giveaway would have been invalid because it destroyed all public use of that harbor. So I think the logical reading, the scope that you're looking at, the denominator, for lack of a better word, is the water body, the rest of Lake Chelan, or that area of Lake Chelan. And in order to determine whether there's a substantial impairment of that area, we think the best thing to take note of is that this has been there for 50 years and nobody has had trouble recreating, navigating on this lake.
And is quieting title, where there's great disruption in confidence in title, a sufficient reason to give up a case-by-case review of the fills in question?
I think that's one very good reason, but there were other reasons here too, because the second aspect of Caminiti is, does it promote the jus publicum? And this land, there's not a use or development on this property that can't occur without this review under the Shoreline Management Act. And that's a robust law that starts with surveying the land scientifically, finding out its ecological functions, finding out its uses for the community, and then you zone it and regulate it and plan for the future use. And that's done from the top down because it's regulated from 1958, the standards in the Shoreline Management Act that this court quoted in Caminiti and in other cases, and from the bottom up because the locals and the local citizens have participated in developing the master program. So through those robust laws, you control the property's use so that there will be navigation access, public access, that you have water-dependent uses. For example, if there were a marina on this property, that would be promote the jus publicum, and there would be no question. So Our confidence is that the Shoreline Management Act will control the future use of this property and thus promote the use publicum in the area.
Can I pause there and ask, that description of the public benefit goes a lot to land use generally, but if this is land that, let's say, is 100% of the time above the water, wouldn't you say you have 100% impairment of the navigation over this land?
Yes, you can obviously not navigate there. That's
So would the test you're promoting then in terms of looking at that second prong just be if it's generally good, because we now have better regulation over the other uses of the land, that it totally impairs navigation is not a problem under the jus publicum?
I think that's the test this court has set on that second prong in both East Lake and in Portage Bay and in Caminiti and in Wheaton and in Orion. In all those cases, all the way back to Hill in the turn of the century, the court has looked at the fact that lands can be filled, and one way you can lose the jus publicum without any violation of the public trust doctrine is because what you're doing is promoting, for example, the fill of the Seattle waterfront in order to develop the Duwamish Harbor Island area. And even though ultimately not every square foot of that is used for waterfront access,
I guess my question maybe in a nutshell is, does any of the benefit have to go to navigation? Does it have to improve the actual jus publicum interest? Or can it just be good for the economy, good for the state? We'll just fill the whole lake because we'll create more jobs.
I think the Caminiti test looks for something that's promoting the jus publicum in a legislative sense. And here the legislature, by applying the Shoreline Management Act, does just that. This court has recognized that. Or in the alternative, that there's no substantial impairment, and we meet both those prongs of Caminiti.
Mr. Geck, if this Three Fingers is subject to the law and is not within the exception, well, I guess if it's within the exception to the law would be the way to say this, how extensive a problem is this in terms of other properties?
We know of no others in the state at this time. We've surveyed every foot of shorelines in the last generations twice in order to develop shoreline master programs for all the waters and the shorelines and the navigable waters that are covered by the Shoreline Act. So I see I've run out of my time. I'd like to make sure that my counsel has it. Thank you.
Caminiti, I should let you introduce yourself.
May it please the court, my name is Eric Miller and I represent GBI Holdings.
Is the Caminiti test the right test, or do we modify it when we're talking about fills that are this long-standing?
The Caminiti test is the test that this court has applied to the Shoreline Management Act, and then we're asking the court to apply that test again here. And applying that test, I think there are a couple of observations that are helpful in understanding how to frame the application of that test. The first is that this court has never before used the public trust doctrine to invalidate an act of the state legislature, and this is not a case in which to do it, because under Caminiti, one of the things that the court said in Caminiti is that the requirements of the public trust doctrine are fully met by the controls put in place by the Shoreline Management Act. The court said much the same thing in the Portage Bay case, that the Shoreline Management Act is the present declaration of the public trust doctrine. So the legislature has attended to the considerations that animate the common law public trust doctrine. It has implemented them in this statute, which, as Mr. Geck was saying, imposes extensive controls on the use of navigable waterways, the use of shoreline areas.
So there's no other role for the court in any of these challenges other than to determine whether the legislation has been complied with?
That is what the court has said in Caminiti, is that the Shoreline Management Act implements the public trust doctrine. It is not an abdication of the state's sovereign authority to regulate.
I'm not sure we said that for all times, though, to be precluding all challenges for all times.
Well, I mean, what the court also said, the court also articulated a test, and even if you don't view that as an application of the test and an upholding of the statute, which we do, but even if you view that as leaving open the possibility of future examination of the statute. The test that the court articulated is whether the state, and I'm quoting from Caminiti, whether the state, by the questioned legislation, has given up its right of control over the use publicum. So you look at the legislation, that is the Shoreline Management Act, not a particular fill that is subject to it. Looking at the statute, you ask, has the legislature given up the state's control over the use publicum? And the answer is plainly no, it has not. It has exercised control. It has imposed a complex regulatory regime to ensure that uses of the shoreline, that uses of fills are consistent with the goals of the legislature in balancing ecological, aesthetic, and economic considerations in the use of the shoreline. That's the judgment that the legislature made, and part of the judgment that the legislature and the people made when they adopted the statute.
And then going on to part two, do you analyze the particular project?
Well, you only get to part two under Caminiti if there's been an abdication of control. So,
so your argument is that you never get to part two anymore after the enactment of the Shoreline Management Act.
That's our position, but if you want to go on to part two, the statute easily satisfies that as well, because the question is, has the state promoted the interest of the public in the use publicum? And as I was just saying, the state made a judgment about the many different interests that navigable waters and shorelines can serve, and it set up a regime of balance.
Mr. Miller, do I understand your argument then? If as we analyze the Shoreline Management Act and its balance globally under that first question, that the answer to that, which in your case is a no, the state has not abdicated its jus publicum, would be the same as to post-1969 fills, structures, docks, as it would be to pre-1969, wouldn't it? Because all that same balance and the intense regulation certainly applies going forward.
Well, post-1969 fills, of course, aren't protected by the statute.
Well, but I understand you to be saying the Shoreline Management Act in its entirety shows that the state hasn't given up its control, hasn't surrendered the jus publicum. Why would that be limited to items, structures, areas inside the savings clause?
Right. So if I understand the question, if for example you had a post-1969 fill or structure that was permitted and authorized through the
Then aren't you saying
procedures,
that we're good to go? The Caminiti test is also satisfied as to that?
Yes, that if the Caminiti does not leave open the possibility of a challenge to something that complies with the statute, on the theory that it nevertheless violates the public trust.
Is there anything covered by the Shoreline Management Act under your analysis that could ever be subject to a public trust claim that could ever survive the first prong of the Caminiti test?
No, because as the court said in Caminiti, the requirements of the doctrine are fully met by the controls of the Shoreline Management Act. And
Mr. Miller, before you move on, I'm just curious about one thing. How did GBI come into title of this property?
I don't know how they initially came to own the property. The fill was placed as part of the construction work on Highway 97A, which was performed under a contract with the state. And I don't know how the initial ownership of the property came to be held by GBI.
Does that have anything to do with the application of the statute?
No, it is, for purposes of application of the statute, the significant facts are, one, that it is in fact owned by GBI. If it were owned by somebody else, if they filled someone else's land or filled the state's land, then there would be a trespass claim.
Well, somebody else might be the state. That's what I'm wondering.
Right. There's been no suggestion that this is in trespass or that it is not, in fact, owned by GBI. I think the other relevant feature of the history of this particular film, of course, is that this is land that was not initially. There was some talk earlier of the Article 17 of the state constitution. This was not originally submerged land. This was originally dry land that is only seasonally submerged as a result of the dam that raised the level of Lake Chelan. So this is not like tidelands that were sold by the state. This was private land all along, and then it became subject to seasonal flooding. Whatever the questions there might be about the authority of the state to alienate.
That was by GBI's own granting of a right over their land so that the dam could be built, right? They gave that access to the water to their own land by their own doing.
Right, but we think ultimately it doesn't make a difference here because the question for constitutional purposes is the same, that the Shoreline Management Act is a valid implementation of the public trust doctrine and fully satisfies it. But just as a historical matter, this was not submerged land that was initially subject to Article 17. It was dry land that later became subject to flooding. And I think I would also add that when we're talking about what the scope of the legislative function is here, I think it's instructive to look at Wilbur itself. Wilbur, in footnote 13 of Wilbur, the court emphasized that it was recognizing a claim in that context, in part because the legislature had not acted. And the court invited legislative action on this subject. And then just a few years later in Harris, considering a somewhat similar claim objecting to filling of tidelands, the court said that there wasn't a Wilbur claim there because that fill had been authorized by the legislature. So I think Caminiti answers the question here, but it's not just Caminiti. Caminiti is of a piece with a line of cases that have recognized the role of the legislature in making these judgments. And one of the judgments, of course, that the legislature made is that there should be a general rule governing pre-Wilbur fills, that rather than a case-by-case inquiry of the sort contemplated by the plaintiffs here, because part of the legislative judgment was that the interests in stability and finality in promoting investment are best served by a general rule.
But to be clear, there's still a case-by-case review as to trespass or other statutory violations, just not as to the fill itself.
That is correct, and we agree with the state that that the proviso has work to do in saving trespass claims and other kinds of statutory claims, but it doesn't save impairment of navigation claims because the whole point of the statute was to cut.
So I realize your time is up, but I asked Mr. Geck whether someone who was challenging a post-1969 fill could bring a state statutory nuisance claim. I understood him to say yes. I believe your answer would be no, insofar as that nuisance claim would be based on navigation.
Well, it would be based on navigation, but it's not cut off by Section 270 because Section 270 cuts off Wilbur claims only for fills that were in place by 1969.
Cut off by the Shoreline Management Act under your Caminiti analysis.
Because the provision of the Shoreline Management Act that cuts off those claims is Section 270, and it applies only to pre-1969 fills, so it would not save a subsequent fill. Thank you.
Mr. Dunkers. About 8.5 minutes.
Thank you, Your Honor. A couple points that I'd like to get into as the court considers the death of the public trust doctrine. This idea that a public trust claimant cannot bring an as-applied challenge is absolutely incorrect. I mean, that's precisely what this court looked at in the Orion Corp case, which followed the Caminiti case by 10 months. Caminiti did say that the requirements of the Shoreline Management Act are met by, or the PTD, Public Trust Doctrine requirements of the PTD are met by the Shoreline Management Act. But that was looking at a statute that applied a regulatory framework under the Shoreline Management Act to the uses at issue. It was a question about docks and whether private recreational docks could be licensed without paying a fee. And so there you have a Shoreline Management Act as well as another host of state statutes that controlled the uses at issue. And that statute was narrowly tailored. It applied only to recreational docks. It didn't apply to, in the way that the savings clause applies to recreational docks, commercial fills, recreational fills, whether they affect navigation or recreation, whether they're deteriorating, whether they're functional, it's just blanket application. So the Caminiti statute was narrowly tailored, and it was applying regulations and law that existed to govern the uses in question. That's not what we have here. And in the Orion decision, again, that followed Caminiti by 10 months, the court looked at a specific fill separate from the Shoreline Management Act. It looked at the SMA, but it said that the dredging project on Padilla Bay in Skagit County was invalid under the Public Trust Doctrine. And that was because it was without regard to whether the Shoreline Management Act allowed the uses in question or not. In fact, that court remanded the case because it wasn't clear whether any uses that were profitable would be consistent with the Public Trust Doctrine. And so this idea that the Shoreline Management Act subsumes questions under the Public Trust Doctrine is not what this court has looked at in its previous decisions. It's not what the court looked at in Whedon, a position that I believe was authored by Justice Johnson. The court didn't, it was a banning of personal watercraft. The court didn't look at and how it applied in San Juan County. The court didn't look at how a ban to personal watercraft would apply in King County or Chelan County. Looked in San Juan County. Orion looked at how this fill on Padilla Bay was impacted under the Public Trust Doctrine. An as-applied challenge is precisely what we're asking this court to do. And again, in some of the previous decisions, I see that my clock's not ticking down here, so I'm going to
Take advantage of that.
Yeah, right. To the chagrin of the
According
court.
to me, you'll be done at about just before 10:40, but I'm going to
Okay.
be sure the bailiff works on that.
Okay, thank you.
Excuse me for the distraction.
No, thank you. So I was just trying to highlight this court has clearly done as applied challenges. That's what we're asking the court to do. And the idea that the Public Trust Doctrine no longer has any role because the Shoreline Management Act applies to prospective uses in the future. It's just not with the savings clause.
So can I ask you specifically about that? Because, again, I'm trying to get my arms around the difference between your subconstitutional argument based on the proviso to the savings clause and your public trust broader argument. I guess my first question is, do you read the savings clause as sort of forgiving prior non-conforming stuff,
Yes,
uses?
I see it as a grand bargain.
Doesn't have to comply with anything in the shoreline management
Seems to
Act.
me like a bargain.
Is that the source of your argument that this is an abdication of the state's
Use publicum. Yes, Your Honor.
Okay, is that a constitutional argument or an interpretive argument to avoid? I'm just still trying to understand the strength, the source
Yeah,
of the argument.
it's and this gets to the question that Justice McLeod, I think, hit me off with at the beginning. Is this a constitutional issue? I mean, Article 17 of our Constitution, the state's assertion of ownership of the beds and shores of navigable waters, incorporates the state's duty to protect the use publicum. So in that respect, there is a constitutional element to the Public Trust Doctrine.
Do we have anything else in our law that only has a constitutional element to the doctrine? I mean, even stuff that's in the penumbra is considered like a constitutional right, deserving of the highest respect. And this seems like so different from everything else.
It does, Your Honor, and that's what's striking about the Public Trust Doctrine in my reading of cases from the state and across the country, is it is really its own doctrine. And it has common law origins, but it has constitutional foundations, and that's why the Caminiti Court used the constitutional word in the context of the Public Trust Doctrine so much. But the Public Trust Doctrine really is unique, and there's a statement in the State v. Sturtevant case that it's the only right which the state has ever undertaken to maintain in trust for the whole people. That's a 1913 decision from this court, and the court, the essential ruling was that the riparian property owner's right to title goes to navigable waters, and it's this right that is so unique, supports that. And so this is a constitutional, there's elements of the Constitution in the Public Trust Doctrine. And, that's what we see going back to Roman law, then adopted in the French Middle Ages, in French law, and in the English common law. The state accepts ownership with the duty to protect the navigation and recreation rights of the public. And, you know, again, this idea that the Shoreline Management Act has subsumed, has been subsumed, the Public Trust Doctrine subsumes the Shoreline Management Act. The 1998 decision that Justice Johnson authored adopts heightened scrutiny to impairments under the Public Trust Doctrine. Heightened scrutiny, has a constitutional element to it. Heightened scrutiny does, and what that means is that the court really takes a careful review over impairments to the public's right to navigation, and that 1998 decision followed the enactment of the Shoreline Management Act by almost 30 years.
But even if we agree with you on that, doesn't that just satisfy or result in an affirmative answer on the first of the Caminiti prongs? But given what we're looking at here, which is long-standing, I mean, this bill has been there for how long?
I believe 1961 to 1962.
Okay,
that's
so
how long it was. They blew off the side of a mountain to help construct a road and dumped it in the
So
lake.
55 years this thing has been in existence. So I guess I'm concerned because under the second prong, it seems so reasonable that the state should be able to say fish can still swim, boats can still float. You know, we're just not going to go back and start over from statehood, and that would meet the second prong.
Well, and thank you for bringing me back to the record. And I think this is working again. I think I have a minute and 20 seconds left. So, so the record, again, the as-applied challenge, the record here, this, prong 2A of Caminiti, does it promote a public interest in the use publicum? I believe that was a question you asked earlier, Justice Stevens, is that, is this any public interest or is it a interest in the use publicum? And it is the use publicum. That's what Caminiti says. And in this case, there was no facts to support any impact or public interest in the use publicum. And that's what distinguishes it from the whole body of public trust cases. The Harris v. Hylobos case, you had a Tacoma Waterway, commercial navigation. There's a public interest in the use publicum. There are some cases, I think the Hill v. Newell was one case that was mentioned by the state, the straightening of the Duwamish River in Seattle. You're promoting the public interest in the use publicum by commercial navigation. There are some cases in California that can suggest the public trust doctrine can be lost. And that's what the Berkeley case from 1980, the California Supreme Court talks about. And I invite the court to take a look at that because they chide the legislature there for, in the 19th century, giving a wholesale abdication to properties in San Francisco Bay. They invited a particularized review. That's my time. The court should do so here. Thank you.
All right, we'll be in recess until 1:30.